Joining me tonight is CNN legal analyst Jeffrey Toobin, also Paul Callan. Leon Rodriguez is here. He's the former director of the U.S. Citizenship and Immigration Services. Kansas Secretary of State and Trump supporter Chris Kobach is joining us by remote. So is constitutional law professor Elizabeth Foley, legal analyst Laura Coates, and Harvard Law School professor emeritus Alan Dershowitz. Professor Foley, one of the main arguments from the Department of Justice was that the president's decisions about immigration, when motivated by national security concerns, are unreviewable. I want to read a section of the ruling which basically shoots down that argument. It says, quote, "There is no precedent to support this claimed unreviewability, which runs contrary to the fundamental structure of our constitutional democracy." To that, you say what?
Look, I think that's fundamentally correct. I don't think that the president's decisions on national security are unreviewable. That's really not the argument that the administration is putting forward here. The argument instead is that under a Supreme Court precedent called Youngstown, when the president acts with the explicit blessing of Congress, which the president has done here, he is entitled to a presumption of constitutionality. When those two political branches are in agreement, the court should defer on the issue of national security. I do not see that the Ninth Circuit engaged in any such deference here. And let's keep our eye on the prize here.
But the Department of Justice did argue unreviewability to this court.
Yeah, in a very half-hearted way, but you have to realize that they
actually just seem confused. I mean, the guy paused for a long period of time when asked about this and then said, yeah, it's unreviewable. Clearly, they were not impressed by that argument.
Yeah, and they shouldn't have been impressed by that argument. I mean, everyone agrees, I think, that the Constitution would trump any statute or any presidential executive order taken pursuant to a statute. But I do want to remind the viewers, though, that this is a statute that Congress has passed. That statute says that the president may suspend the entry of all or any class of aliens if he deems it appropriate in the national interest. So he does have the blessing of Congress. This is not just the Trump administration. This is Congress also weighing in on this and blessing what the president has done, which is narrower than what the president could have done under the statute. So what we have here is a court that's being very aggressive and not giving the president and Congress the deference that a court would normally give them.
Laura Coates?
Well, you know, that's true. That is a part of what Congress did. The other part of what Congress did is say that you cannot discriminate based on national origin, which is part and parcel to what's going on here. But remember what's really the case. The court did give extreme deference. They talk about it a great deal in the opinion that they were trying to defer, and they recognize that the president should deserve some deference. However, that deference is contingent on there actually being a national security issue. The court was trying to resolve this very discrete point. Please tell us why we should reinstate a ban and not go back to the pre-travel ban status quo where we had vetting measures in place. Tell us why you would be harmed, federal government, if we return to the vetting that we had in place. And to that, there was crickets. The Justice Department could not answer what the newfound risk would be that would require this court to reinstate the ban. And that is why the court said, we're not going to do this.
Leon?
I mean, I think that's a critical issue here, which is that nationals of these countries were already subject to the most intensive vetting of any travelers to the United States. In particular, those who were coming here as refugees, and in particular beyond that, those who were coming from Syria. So the idea that there was a need to do more than was already being done in any kind of substantial way is not actually supported.
And Leon, just from your expertise and from your past profession or past role as the director, how will this actually work now moving forward while this is going through the court system? I mean, it goes back to the way it was, but that doesn't mean that, you know, to paraphrase Donald Trump, that a bunch of bad people are going to kind of rush in the country. It still means everybody has to go through the same process of applying for a visa, the vetting that...
Let's take the example of Syrians, because this is the thing that we've argued about a lot. If you look at the history of our adjudication of Syrian refugee applicants, many of them have been denied. Because during the process of looking at those cases, we found bad information in law enforcement intelligence databases. We didn't find them credible during the course of interviews. That means that there was a process in place there that was actually working. There is always room for some improvement, but the fact is that the process was actually substantially working before.
So, Secretary Kobach, the president said earlier tonight that his decision was political, that the court's decision was political. I mean, as has been pointed out, of the three judges, there was a Carter appointee, a George W. Bush appointee, as well as an appointee from President Obama. Do you see this as political?
Well, as someone who has argued some of these very same issues in various courts of appeals throughout the country, I see this as a very weak decision. And when you have a decision that is full of so many gaping legal holes, you sometimes have to wonder where the judge is trying to reach a conclusion that they wanted to reach without sufficient legal backing to get there. Let me give you just a couple examples. Standing of the states. I've argued cases where states are trying to assert standing to challenge an executive immigration order of a president. What we had here was the states asserting that injury to a visiting student is, through several leaps of logic, injury to the state itself. That would not fly in any other circuit except the Ninth Circuit. I'm absolutely convinced of that. Irreparability. The court simply concluded without any analysis that the injury to the state is not irreparable. That means you can't repair it. And that the court was saying, oh yeah, you can. Think about what we're talking about here. We're talking about a national from a terror-sponsoring region or country who then is allowed to come in and then vanishes into the fabric of America like the 9/11 hijackers did, like many terrorist operatives do. You can't repair that. You can't magically find that foreign national and say, oh, here he is. So it is irreparable harm. The due process analysis. What the court did is it took the most favorable person and said, there are multiple categories of aliens affected here. And they took the most favorable one, that is to say a lawful permanent resident who's already gotten his green card, and said, yeah, that person needs some time to make his case before you revoke the green card. But there are all kinds of other aliens affected by this executive order who do not have the same due process claim. They're standing outside of the country. They've never been given anything by the United States. And the court was sort of taking the due process analysis and applying it to everyone. There's so many legal holes in this opinion. I would love to appeal this because it would be easy to go against this on appeal.
I want to talk to our other attorneys about the issues you raised, and I know, Professor Dershowitz, you've raised the issue of standing and how the Supreme Court may view it differently than this court. We got to take a quick break. We're going to continue the conversation in just a few minutes. Later, we'll also talk about the political impact this loss may have on the president, who obviously loves to focus on winning. Much more to get to tonight. Stay with us.